I appreciate the opportunity to speak before you. I added a little bit of that political stuff just because just gives you an idea that I'm not solely just into workers' compensation. I actually have a life doing other stuff too. But thank you very much. I appreciate it. Over the course of my career, I have deposed hundreds of physicians in both civil actions as well as workers' compensation matters. And I can honestly tell you that I believe trying to get a physician to change his opinion in deposition is one of the most difficult things that I have to do in the law and in my area of practice. I can convince judges to change their tentative rulings in civil matters simply by my oral arguments. I can convince opposing counsel to actually see my side of a particular case to resolve it. But when it comes to physicians in a deposition, it is utterly the most challenging thing I have to face in my practice. But it is in depositions overall are equally challenging to physicians as well. For each of you as a medical legal evaluator, you oftentimes don't even know why your deposition has been scheduled. Oftentimes, unless your staff asks, you don't even know which side who has actually scheduled the deposition. And when you get the notice and your staff advise you that a deposition has been scheduled, you might get a little nervous. You might feel that your opinion's being challenged. You don't necessarily know what questions are going to be asked. You don't know what's being challenged. Is it your opinion? Is it your facts? Is it your analysis? Is it any number of these legal issues that we've discussed all morning long? And it certainly can be any one of those. But when you walk in that door, when the court reporter's set up and opposing counsel is there, you don't necessarily know what's going to come about. For an attorney, it's challenging because I need to develop a logical, strategic timeline to be able to convince you to change your opinion and potentially see things as I do or as my client has. It's difficult for us because most of us, there are plenty of lawyers out there that do have medical degrees, but they may not have necessarily practiced law. Me in particular, I haven't practiced medicine. Practiced law. They haven't practiced medicine. They may not have a medical background. Once the AMA guides came in, I certainly will defer somewhat, let's say, to you on the AMA guides. But for the most part, a lot of attorneys who are actually questioning you probably don't know the AMA guides quite as well as you do. They might have read that particular chapter that might be at issue for their questioning, but they'll disregard chapter 1, chapter 2, maybe chapter 18. So certainly it's challenging for attorneys that don't have that medical background. What I'd like to do today is to provide you some of my general personal recommendations, some do's and don'ts, as I would say, are best practices. Again, this is from my personal perspective. These particular areas that I'm going to go through, I have been successful in challenging medical opinions or getting a physician to change their opinion based on the particular tactics that I use in depositions. Or I have successfully argued before a judge that a medical opinion should not be relied upon because of certain aspects that I brought out in a deposition. And when I first prepared this presentation, this was not my number one thing I was going to talk about, but I deposed three physicians this last week. And I said, I've got to change it up. And I got to say, I was quite surprised about my first number one recommendation. Be prepared. It's a cliche, but let me tell you exactly what I talk about. First of all, you're going to read your own reports. Granted, I got that. But one thing you should keep in mind, which I was very astonished about, 2 out of the 3 physicians this last week did not know whether the case was accepted or whether it was denied. You should have that at the forefront of your mind while you're preparing, because if, for instance, the case was denied and you found industrial causation, more likely than not, you're going to be challenged on causation. That immediately gives your potential focus and helps alleviate some of the potential anxiety you might have by going into a deposition not knowing what the questions were. If a case is accepted, but certain parts of body might be at issue, and again in your report you found industrial causation as to some of those parts of body, then again that might give you a clue as to why you're going to be questioned. Dr. Lewis had actually made a good point earlier this morning about reading the advocacy letters that you're sent. And granted, I know that you probably don't get very good advocacy letters. Mine are particularly good, I think. But, and I'm sure Adam's are as well, because we make it a point that you should know exactly what those precise issues are. Take a time to read it again before the deposition, just to see by chance, did you happen to not look at it before you wrote your report? Was it at the top of your head? What were some of those issues? Because if you rendered an opinion that might be different to a defense advocacy letter, again, that gives you an idea of what you're likely going to be challenged on in your deposition. One other suggestion that I make as you prepare is know what records you reviewed in preparation for your report and your ultimate opinion. What I mean is sure, you may have an historian that goes ahead and does the record summary for you. Your record summary is going to be in your report. But I strongly suggest you put a Post-it note next to you and say, I reviewed Kaiser, I reviewed the deposition transcript, I reviewed job description, personnel records. Just highlight that. Because more than likely, at the time that you prepared your report, you relied on those records. When you're sitting in deposition and somebody tries to challenge you about whether or not you reviewed something, you can be confident to say, yes, I reviewed those records, and that helped form the basis of my underlying opinion. Trust me, I've heard it time and time again. A doctor would not commit to saying whether or not they had reviewed the records, and they're right there in their report. Well, I need to know because my subsequent questioning regarding particular details of that report may not even make sense, and then our deposition is not going to get us anywhere, and nobody's opinion and nobody's presenting argument that I might have at trial could even convince any judge whatsoever. At this time, and based on what happened this week, I generally had not ever challenged a physician about the time in which they took to prepare. I have given equal respect to each of the medical legal evaluators that when my client is paying for your preparation time, that you're actually doing it. But I intend at this point, based on my experience this week, to actually ask each and every physician that I deposed exactly what they did in preparation. Because what I encountered this week was, from my perspective, a little lack in professionalism, because it completely told me that there was no preparation that was involved, and my client was actually paying for preparation, because all the physicians did was immediately refer back to their report and never demonstrated that they actually had any cognizant understanding of the facts and circumstances of the case. And that's quite troubling. So I do encourage you to actually be prepared. By being prepared, whenever you're challenged over particular inconsistencies, you can certainly bolster your own opinion to say, I have reviewed those records. Those were the basis upon which I made my underlying opinion, and I'm here to explain in deposition precisely why I believe, X, Y, and Z, whatever the challenged question may be. Number two, I highly recommend, if it is available to you, that you review an applicant's deposition transcript again before a deposition. Let me tell you why. We're sitting here talking about depositions, but deposition testimony by an injured worker is under oath, just as yours is. Deposition transcripts of injured workers are used by district attorneys in order to consider the possibility of fraud charges. That's how important they are. Deposition transcripts are used by me at the time of trial because you would expect that an injured worker is going to testify consistently with the testimony that he provided in his deposition. If he or she does not, you can be certain that I will bring it up and I will impeach him or her. And when I do that, and I do it successfully, then a judge is going to think, wait a minute, what can I really rely on here? Has the injured worker actually been able to meet their burden of proof when now they're giving inconsistent stories in sworn testimony at trial and sworn testimony in a deposition? So to be honest with you, I find it very astonishing the number of occasions in which I have questioned a medical legal evaluator about the impact, the influence sworn deposition testimony of an applicant actually has had on their opinion. And more likely than not, I hear they don't give it any significance. But the history that is being provided to your historian or to you during an evaluation is not under oath. So when you think about either a district attorney for that matter, or even a judge for that matter, what weight, which should get higher weight? Sworn deposition should get higher weight than just the history that's provided to your historian, because one is actually under oath and the other is not. And I raise this point because inevitably I will outline inconsistencies between the history that's in your report versus what an applicant told me in deposition. Now let me give you an example. I'm not talking about subjective complaints. I'm not talking about progression of pain or anything like that. I take depositions early on in a case. I can take it within, if it's litigated quickly, I might take a deposition within 90 days of the date of injury. You're more than likely not necessarily seeing them within 90 days unless it's not litigated, then you might, and if there's a significant issue. But for the most part, my depositions might take place before you. So let me give you an example of something significant. Even in an accepted case, how it could change by the time it gets to you. For instance, if I question an applicant, it's a slip and fall, they slip, they hit their right knee first, then their left knee, and then land on their butt. Okay, that's exactly what they tell me, because I make it very clear in deposition to ask them, what's the first portion of your body that struck the ground? I go through all of those details. So that's the description that we have within 90 days of a particular injury. 2 years later, when you're evaluating, and the history that you put in your report is that they fell on their right knee, their left knee went to their left hip, and then hit their left shoulder and hit their head. Astonishingly, I can see and have seen that, in other words, the parts of body end up becoming an issue is what the point is. But a physician may not necessarily recognize the inconsistency between the depo transcript and the history that's actually provided in the report. And obviously it is, because those parts of body that weren't touching the ground 90 days post-injury are now becoming an issue. And that's just an example of some inconsistencies factually, that if you have the applicant's deposition testimony in your head prior to moving into a deposition, when you're challenged on those potential inconsistencies, you will be prepared to render an opinion either on the spot or potentially think about pausing and taking an opportunity to further evaluate it to determine if the facts are material enough to cause you to change your opinion. And that leads me to my next point, is when those inconsistencies are brought up, I suggest you be open to changing your opinion in your report. Because if those facts were overlooked and they're raised in deposition, I'm not suggesting that you're mandated or obligated to come up with an opinion at the time that you're under oath and you're being questioned by somebody like me. Certainly take the time if you feel it is significant enough and material enough to a determination of, for instance, industrial causation or impairment or apportionment. If you need to pause, that's fine. I'll give you as much time as you can in deposition. But I will also, if you need additional time, asking for additional time in which to reevaluate it and write a supplemental report is certainly to your prerogative as well, because trust me, what I do see oftentimes by physicians, if I bring out those inconsistencies, and if that physician is not prepared, what are they going to do and what they did this week? They're going to, quote, double down. They're going to double down on their opinion. They're just going to read from their report into the record, and it's going to infringe on their credibility. Because if you're going to discount and discredit the facts that I have brought up that are inconsistent, I will make the argument to the judge that you were ill-prepared and that your deposition testimony also cannot constitute substantial medical evidence, and I will ask that it be stricken as well as your report, especially when those insignificant or the inconsistencies are material to your opinion. Your opinion is only as good as the information upon which it is based. So again, I just caution you against doubling down on your opinion, reiterating it in a deposition in light of the inconsistencies or the challenges that are being raised by a physician or by an attorney such as myself, because it will cause a judge to actually question your opinion. That leads me to one other point, just real quick, I was going to make in the introduction, is that the other reason why it's challenging for doctors in depositions is that we actually know the judges. We know what judges, especially the older judges for that matter, and Adam can attest to this, when they get talking around the coffee room, they'll comment about your reports. We know certain judges might say about a particular physician. We'll know if we've got potentially a report that may not be so good, and we know a judge doesn't like that particular doctor, then maybe we might want to kick that judge and rely on that report before another judge. So reputation in this industry is key, and so that's one thing to keep in mind. The fourth thing that I would like to talk about is make sure that if you haven't done it in your report, we talked about it a lot, that you substantiate your use of Alvarez. Today, you've heard time and time again for Dr. Cocciarella and Dr. Lewis that it is very helpful for you to actually explain. I think it was Dr. Lewis that had that paragraph, or maybe it was Dr. Cocciarella, that example paragraph about how to explain use of Alvarez. It's very, very important, because more than likely if I have to come in and depose you and the topic of Alvarez comes up, it's because all that the physician had done was make a statement that I'm going to use chapter 18 because there is no other chapter that I can use, and so under Alvarez I give 3%. That's not going to fly. I mean, that's a conclusory statement that's not really going to work. I also want to caution you about the fact that case law has expanded and has actually what we call the prodigy. All the cases that have come down behind Alvarez have actually limited it into basically extraordinary circumstances. There are a number of cases that actually talk about using Alvarez only in extraordinary circumstances. Adam certainly can argue around that as well. But there are cases that actually suggest that you should only use it under those particular circumstances. So in deposition, don't necessarily be led astray that you are forced to perform an Alvarez analysis. I'm a defense attorney. If you found a chapter and a method of impairment that's consistent and you've applied it in other categories or with other applicants, that's the purpose behind the use of the AMA guides to begin with. So don't necessarily think that because Alvarez exists and an applicant's attorney is in there asking you questions to challenge you to say, well, did you think about this method? Did you think about this chapter? Did you do this or did you do that? It's not required that you consider doing that. Keep in mind that if you have a substantial basis upon which you can rely following your clinical examination and you find that there is impairment that you can utilize in the AMA guides, then that's sufficient, unless you think that there's something extraordinary. With that in mind, keep in mind that there is a recent case also that, and I'm going to challenge this, I actually have a trial set on this particular issue. There's a case called City of Sacramento, which again reiterates the fact that you're to use a chapter, table, or a method of assessment of impairment that's in the AMA guides. A physician may not arbitrarily assess impairment. Now, it seems kind of logical, but I deposed a physician that admitted to me in deposition, which I knew already, that the method that he had used for the assessment of the impairment was not a method that was in the AMA guides. What he did is he had arbitrarily came up with a percentage of diminished capacity of some sort and then multiplied it by some other percentages that were in the AMA guides just because the condition, which in this case was tendinosis, maybe epicondylitis, it wasn't in the AMA guides. There wasn't any ratable impairment. And so in his clinical judgment and his clinical expertise, he felt that this was the best manner in which to assess impairment because he just simply didn't like the fact that the AMA guides didn't allow for the impairment under those circumstances. Well, I'm going to use this case to actually indicate, because the doctor doubled down and actually reiterated that the method was not in the AMA guides, and he just wanted to qualify to say it's allowable because in my clinical expertise, I'm going to do this under Alvarez. And so if I ever have the opportunity, I'll let you know how I will succeed. But I really believe that I was able to just walk the physician down and have him double down on confirmation that what he did was not using the AMA guides. And so we'll see how that turns out. Apportionment. So this obviously is another area, a topic that you probably get into in every deposition that you're ever going to be involved in. And so certainly because it is an area that both sides have interests on. So either side is going to depose you, more than likely the issue is going to come up. And I appreciate Adam's discussion. He's absolutely right. It's my burden. It's the defense burden to actually prove up apportionment. And oftentimes that's very difficult with some practitioners in the medical community that might have more of a bias on the applicant's side. But they'll just say, oh, my apportionment will be conclusory. And so then I have to go in and say, hey, why did you do what you did? If I like what you've said in regard to apportionment, but yet you said it too conclusory, and you didn't give an adequate explanation as to the basis for your actual percentages and your actual apportionment, I will still take your deposition. But I'll do it to bolster your opinion because it's my burden that I want the judge to rely on your opinion. I need to make sure that you have filled it up, made it substantial so that the judge could actually rely on it, because Adam's right, it is my burden to prove that up, and I must do so before he ever files for a hearing to try and pull the rug out from underneath me before I have a chance to actually get in there and clean that up. But I will do that. Also interesting that, so a little bit of overlap with Adam is, again, I recommend that you do not default to another physician's opinion as to apportionment. There are cases that have come down and have admonished physicians to say, hey, these physicians over here in the case were able to do an apportionment determination, so why didn't you? Keep in mind that if you did default to another physician, I will probably come in and say, again, it's my burden. I need to make sure that you understand. And if you have a thorough understanding because you've been prepared, then you should be in a position to be able to make an accurate determination and render a bolstered, substantial opinion as to apportionment. A couple of comments just on this real quick. In response to Adam. So I jotted down a few notes. I like Benson. Nothing wrong with it at all. So, and the reason I say that is I understand Adam's point in the case that he brought up, but Benson actually, the discussion in Benson is a logical, rational explanation for the changes in the law that occurred, for changes that actually occurred in 2004 after SB 899. And it goes back to a supporting of a legislative purpose behind SB 899. And we've all been, those of you that have been in the industry for a long time, you've always seen with different governors and different legislatures, the ebb and flow between the changes made in favor of an injured worker side, changes made in favor of the defense. And Adam's right, it does come down to money also. But the other thing you have to keep in mind is that the changes in the law actually, and what is supported by Benson, is that defendants, employers, should not be liable for anything other than the direct percentage of the impairment that is attributable to the injury that was caused in their capacity. So in other words, in Adam's example where the officer had 2 injuries within months apart, for a single employer, granted, I can see how he might think it's unfair. But what if that gentleman had a back injury in January with the County of Los Angeles, but then by July was working for the County of Orange? How would that be fair that the County of Orange, just because it might have been the last employer, end up with the fusion and then end up with the far greater percentage of liability for the permanent disability? So this gives you an idea why Benson could be fair in that circumstance, but yet we're not going to necessarily, and legislature's not necessarily, neither is the court, going to necessarily create different rules and different standards depending on those types of factual situations. That's why they also wanted more consistency by adopting the AMA guides. So with that, I do want to thank you for your time, but I just want to say overall, I hope I've been able to provide you some idea of what actually there was one other thing, real quick. Inextricably intertwined, which is what Adam was talking about, which he's correct that in that report it's the medically, what did they call it, medically parcel out. There are quite a number of cases before you use that language. I caution you as a defense attorney. I'm looking at about 1, 2, 3, 4, 5 cases that are suggesting that recent cases are rejecting the conclusory, inextricably intertwined rationale exception to Benson. So just because it exists, just keep in mind that there are quite a number of cases that are going up to the California Court of Appeal and to the board, the Workers' Compensation Appeals Board, challenging that exception. And so there are a number of cases that are not allowing physicians to actually default to that type of Benson exception. So keep that in mind. So
I would agree with that, except that all those cases aren't challenging that the exception isn't part of the law. It challenges the doctor's failure to explain how and why the exception is applicable.
On some of them, but then there's quite a number of them that is factually circumstanced. So, but thank you very much. I'll let you get to lunch.